We're going to go ahead and get started today on our webinar, Understanding Protected Classes. This is a really, really important topic to understand and to go over. When I teach my director credentialing course, we spend some time on this, but I really wanted to do it as a webinar just so we can specifically focus on these 10 to 12 items. And most of us growing up in today's society, a protected class, it should be common sense. And when we talk about understanding protected classes, these are groups of people that you do not discriminate against. Of course, we don't want to discriminate against anybody. We want to treat everybody equally, especially given the industry that we're working in. This is early education. We want to teach our children equality and that everyone has a purpose and everyone has a value and nobody is better than anyone else. But from a legal standpoint, there are what is called federal protected classes. And then you're also going to see that we have state and local protected classes as well. Meaning that you cannot discriminate against these groups of people, and it's a violation of federal law. Now, why it's so important in our industry is that it's kind of a triple whammy for us because protected classes apply to our employees that we hire, the children that we enroll, and the parents that are our clients. So everything we talk about really goes with all three of these groups. Now, the majority of your focus is going to be on an employment standpoint, but especially those of you that do participate in the federal food program, you know that you have to do civil rights training every year, and you can have your contract terminated by the food program in the event that you discriminate against a protected class. So it's a big deal with them. It should be a big deal all the way around. All right. Now, I always like to, warn people, or I don't know if warn is the right word. These protected classes are very outdated. Well, it's kind of funny I say that. They seem to be very outdated, and as we talk about them, it would appear that they are very outdated. However, it seems like recently, over the last couple of years, a lot of these items are starting to resurface, and the need for protection is kind of becoming more evident once again. The bottom line is that you want to treat everybody equally. Now, I don't think any employer, especially in early education, never intends on discriminating against somebody. I don't think that's ever the intent. Usually when we see discrimination lawsuits, it's because of something that was said or done unintentionally. Meaning you didn't really mean to do it. It just happened because you didn't truly understand the protection that was in place. So that's why, I wanted to go over these 12 items with y'all, answer any questions that you've got, and kind of talk about them. Most of them, like I said, is pretty common sense, but there are a few of them that get very, very tricky because you have multiple laws that overlap on top of each other. And it starts to become very vague, and depending on which law you're looking at, which one is going to supersede the other. And you'll be able to tell what I'm talking about once we get to those. So you do have a handout that you'll be able to download off of your control panel. If you're not able to download that, it's under the materials tab. If you're not able to download that, no worries. You can just listen to the presentation. Everything will be on the slides, and we'll talk about everything. The handout does have a little bit more, but you'll get it. All right. So there are 10 federally protected classes that the United States government and the United States Department of Labor have put in place. In the state of Texas, we have 2 additional protected classes. Now, some of you, depending on where you live, you may have a local protected class, something that your city or county has put in place. You'll need to do your own research right there to see if you have anything in particular that you need to be aware of. For example, I know that Dallas has one minor little protected class that's kind of different than everyone else. As long as you're following what we go over here, you'll be just fine in Dallas. And that's Dallas City, not Dallas County. So you'll have to kind of keep up with those things where you live. Today, we're going to focus on the 10 federal classes and the 2 state classes that we have in place. All right. And again, this applies to employees, children, and their parents. And nobody is exempt from protected classes. Sometimes we get the question or comment that, well, I'm a nonprofit organization or I'm a religious organization, so these classes do not apply to me. That's actually false. Everybody it has to follow the protected classes or be aware of protected classes. Now, I did put a little note right there. Religion does have some very specific exceptions to the rule, but the exemptions and exceptions that go along with religion have to be specifically about religion. Meaning they don't cross over into the other protected classes. And we'll talk about that more whenever we get to it. That's probably the #1 question that I get whenever we talk about protected classes is religious exemptions. And yes, there are some, but not all crossover. Okay, so let's go ahead and just kind of get started right here. Some of these I'm going to go through pretty quick because they're pretty easy, they're pretty common sense. Some of them become pretty complex. We'll spend more time on those, and definitely I want to answer any question that you have. And so you can type into your chat screen and you can make your question public, or it can be private just to me. For those of you that have never done this, you've got that option. All right, so our first federally protected class is race. All races are protected by law except for one. The only race that is not protected is Caucasians. So everyone else has a federal protection. Now, you might be asking why is that the case? Why is everyone protected except for Caucasians? Well, this is your first big example of how outdated these are. But when this was written many, many years ago, that made sense, all right? Nowadays, not so much. Would not surprise me if we see some amendments to not only this particular protected class, but several protected classes. I think that we'll see amendments in the very near future. But as of right now, race is protected. All right. Color of skin is also a protected class, and there is a big difference between race and color of skin. A lot of people assume that these are the same, but they're not, all right? You could have 2 individuals that are of the same race that have different colors of skin, all right? And basically what the law is going to look at is, does this person, like in this particular example, color of skin, does the color of this person's skin have anything to do with their ability to perform their job duties? And that's how you're going to look at all of these protected classes. Does it have an influence on the way they do their job, or does it prevent them from doing their job duties? And that's kind of the little checks and balance or tests that you're going to look at with all of these. You know, I've shared this story in my credentialing class a few times, but I'll share it with you now. One of the most famous lawsuits that goes back to this particular protected class is a lady that was addicted to tanning beds. And she went every single day to the tanning bed, and she was a Caucasian woman, went to the tanning bed. Her boss didn't like it and told her she had to stop going to the tanning salon. She said, nope, I'm going to keep going. I like it for whatever reason. I like the way I look. I like the way I feel. It's therapeutic, whatever her reasoning was. And he told her, if you don't stop going to the tanning bed, I'm going to fire you. And sure enough, he did that. And he terminated her employment. She turned around and sued him for discrimination against her color of skin, and she won because the court came back and said that the color of her skin had nothing to do with her ability to perform her job duties. So you know, that's kind of a famous case right there. I tell that story, number one, because it's kind of funny and ridiculous. But number two, we're going to circle back to it because that case is starting to resurface nowadays for one particular reason. So it's very interesting. National origin. Now, typically, where a person is from should not make a difference in their status in your organization. From an employment standpoint, what mainly you have to look at is, does the person have a legal right to work in the United States? This is the purpose of the I-9 form. I-9 form, you're going to have this completed, showing that they can work in the United States, and that normally puts this to rest. Now, we have seen, you know, especially 16, 17 years ago, there was a lot of discrimination based on national origin, you know, especially after 9/11 happened. We got to be very careful with those type of scenarios. Main thing, what you've got to look at is, do they have a legal right to work in the United States? Where they come from has nothing to do with their ability to perform their job duties. Unless there is a language barrier, and we're going to talk about that here in just a little bit. Now, typically, the legal right to work in the United States is the main topic of conversation that we have here. We're starting to see within the past year this become a hotter issue with individuals having to prove their right to work in the United States. You're starting to see a lot of fraudulent Social Security cards, fraudulent data that, you know, people will bring you stating that they are legal and they're really not. So we're starting to have to do a little bit more of a due diligence to make sure that the information provided to us is accurate and legal, and it's not fake. All right. But this is going to get bigger before it gets smaller. So just kind of keep that on the radar. Now, I said language is the other area that this comes in. Because national origin is a protected class, you cannot have a policy that says something like, while at work you must speak English. All right, that would be an example of an illegal policy. All right, you cannot require your employees to speak a particular language while they're at work. Now, with that being said, you could have a policy that says something like, you must be able to effectively communicate with other employees, the children, and their families. All right. So that's a lot different. Being able to say you must be able to effectively communicate is a lot different than saying you must speak English. All right. So make sure that you get the wording down in a legal way. All right. But when I say that you must be able to effectively communicate with everybody, that is a lot of a wider range of topics than just where are they from and what is their first language. All right. We could take that one in a lot of different directions. And if you don't have that in your current job descriptions or employee handbook, then I definitely recommend that you add that, that your employees must be able to effectively communicate. And I've even seen it where it says you must be able to effectively communicate both verbally and written communication with your coworkers, your families, and your children. All right, and I think that's a good idea as well. All right. Now, again, if y'all have any questions or comments, be sure to type that into your chat screen right there so that we can talk about them. All right. Like I said, national origin, it's a hot topic right now. It's going to be an even hotter topic after September 1st. So we'll just keep our eye on that one. All right, creed. This is a very confusing protected class. This is another very hot protected class. I'll go ahead and jump right to the hot area, and that's immunizations. If you have a family or an employee that it is their personal belief that they do not believe in getting immunizations, you cannot discriminate against them. All right, that is a federally protected class, and it has been a protected class for a long, long time. So it would be illegal for you to have a policy that says something like, you must be current on all of your immunizations to be enrolled at this school. All right. Or you must have received all of your immunizations to attend this school. All right, that would be an illegal policy. If it is their personal belief that they do not receive immunizations, then you will get that notarized affidavit and you will have that on file. All right. Now, like I said, this is a hot topic right now because there's a lot of different beliefs on immunizations, whether they are helpful or hurtful, what they do to the body, what they don't do to the body. Ginormous debate right there. Okay. For the purpose of this webinar, you can't discriminate against them. Now, I did put right here, this is currently being challenged in 2 states. For example, California passed a law back in 2016 that effective September 1st of 2016, all children must have received their immunizations to attend a public school in California. That law passed. It was written into statute, and that is the law of the land in California. However, that does violate the federal protected classes. So, of course, there's thousands of appeals that have been filed that are waiting to go to the Supreme Court. Once it does go to the Supreme Court, it's almost a guarantee that it will be overturned and as unconstitutional, and that will change in those states. However, right now, until it goes to court, that's the law of the land. But it's interesting because it has happened in 2 states now, and we're going to have to just eagerly watch and wait and see how the Supreme Court handles the case, because it could take this in a completely different direction. All right. Now, creed again is defined as personal beliefs. And you can see here on the slide, the belief must be currently practiced. All right. That's kind of a big one right there. You cannot have a family that is behind on their immunizations and you say, look, mom, you've got until Friday to get your kid current or he can't come back. And then mom suddenly says, well, you know what? We don't believe in immunizations. All right. That's not going to fly. They have to be currently practicing this. They can't just suddenly decide that this is their belief. All right. And so I said earlier, parents and employees, because remember, in Texas, we now have the vaccine preventable disease policy with minimum standards that you could be requiring employees to receive immunizations. The same principle would apply here. If it conflicts with a belief, they could be exempt. All right. Now, the other, let me tell you a couple of other personal beliefs that fall into this category. Corporal punishment would be an example of a personal belief. Whatever that person's view is on corporal punishment, that is their belief. Now, with that one, they still have to agree and follow your discipline and guidance plan at your school. But what they do at home is kind of their belief. Someone's view on abortion would be a personal belief. And so, you know, having that conversation and failing to hire someone or failing to enroll someone based on their personal beliefs of abortion could cause you a lot of trouble as well. Why in the world this conversation would ever come up, I don't know why, but it has happened. Now, preferences are different than beliefs. And that's kind of hard to understand right there, but there is a difference between a preference and a belief. So I'll give you a couple of examples of preferences. The biggest one would be tattoos. Now, a tattoo is considered a preference, not a belief. So you get to write your tattoo policy to say whatever you want it to say within reason. If you want to say we do not hire any individuals with a tattoo, then you can legally write that policy. If you want to say all tattoos must be covered while you're at work, then you can write that policy. However, I warn you, you're going to have a lot of employees that look like they just returned from war. All right, they're going to have so many bandages on them. You know, a lot of people nowadays are just going to the policy that your tattoos must not be offensive to the children, parents, or other employees. That one is still a little vague because someone's opinion of offensive is going to be different than others. But that tends to be the most popular version of that policy right now. All right. Piercings also fall into the preference category. So again, you get to write that policy to say whatever you want it to say. Now, piercings are a little bit different than tattoos because with piercings, you now have a health and safety issue. Whether it's the back of the piercing coming off and becoming a choking hazard, a child grabbing the piercing and injuring the employee, ripping it out of their skin, which causes a workers' comp claim, a bloodborne pathogens issue. You know, there's all kinds of health and safety concerns with piercings. So you might want to keep that one on a pretty tight leash. The way I have mine written, piercings are limited to 2 piercings in the ear, no greater than 1 inch in diameter. All right. So that would be an example of a good piercing policy. Let me go back. I'm going to back up just a second to tattoos because there are a lot of people advocating and fighting that tattoos are a belief and not a preference and trying to get this law changed. Of course, the courts are coming back right now saying that tattoos are a preference because you were not born with that marking on your skin. You chose to put that marking on your skin, therefore, there's no legal protection. So this is where that tanning bed case that I was just talking about is starting to pop up again because the lawyers and the advocates that are fighting for these tattoos are now using that tanning bed case and saying, look, this lady won her lawsuit based on the protected class of color of skin, but she was not born with that tan skin. But it went in her favor. So that's the argument that some of these tattoo advocates are using right now to try to push this a little bit further. It's very interesting. When you're bored and you have nothing else to do, follow some of these court cases. They get really interesting right there. All right, let me go on to some other preferences that are not protected. Someone being a vegan or a vegetarian or eating only organic food, that once again is a preference. All right, so you get to handle that however you want, whatever is best for your business. If you want to have a no outside food policy, children either eat what's on your menu or they don't come here, that at this point you could have that policy. There's two exceptions to that, though. If you're on the federal food program, you want to be aware of that. If the child has a special diet due to medical reasons, so you have an allergy, you would want to make that accommodation when you have a note from a healthcare professional. And especially now that we have the food allergy emergency plans. If you're on federal food programs, then of course you know you have to make that accommodation for children that have food allergies and you have a note from a healthcare professional. The other exception would be religion, okay? And so if there are dietary restrictions due to a religious belief and that person is currently practicing that religion, then you've got some protection at that point, all right? But otherwise, just the person that's vegan or vegetarian, they really have no legal protection. Okay. So creeds is kind of a big one. It's a confusing one because people like to try to twist this one to their advantage. Okay. So just be very careful and, of course, get outside advice when something sticky comes up in this category. All right. Next one. All right. Here's the big one. Religion. Okay. Now, there are some religious exemptions that are out there. When it comes to policies and procedures and employment practices that are specific to the religious belief, then you've got religious protection. But that only applies to policies, procedures, and practices that are specific to the religion. All right? Then you've got some exceptions. All other employment laws and things like that still are in place. All right. For example, nowhere in the Bible does it say thou shalt not pay overtime. All right. So the Bible says nothing about paying overtime or not paying overtime. So whether you're a religious institution, nonprofit, for-profit, any hours over 40 hours in a work week must be paid at overtime. Sometimes people say, oh, we're a church, we're exempt from overtime. No, you're not. All right. Because that employment law has nothing specifically to do with the religion. Okay. Again, if you have an employee that comes to you and says that they need an accommodation, or they are exempt from a policy due to religious beliefs, you do have a right to ask them for documentation showing that this is a religious belief and that they are currently practicing this religion. For example, I had a employee one time that had a nose ring, and I reminded her that that was against our policy, that piercings were limited to 2 piercings in the ear, and she needed to remove her nose ring. She then replied that it was a religious symbol and that I could not make her take it out. Then I reminded her that she was a blonde-haired girl from East Texas. So it has to be her religion, and she has to be practicing that religion. Nice try, though. You got to give her an A for effort on that one. But it's possible she could have, transitioned over to that belief, but I would just need some proof of that. All right. When I say some religious organizations may not be eligible for this protection, let me explain what I mean by that one. The question comes up quite often, is it okay for, just as an example, is it okay for like the Methodist Church to say we only hire Methodist employees? Or is it okay for the Methodist Church to say we only hire Christians? Okay. Now, in most religious organizations, they actually can do that. All right. If the church is classified as a bona fide club, then a bona fide club can pick and choose their club members. So it is okay for the church to say we only hire Christians, we only hire Methodists, we only hire church members if they fall into that category of a bona fide club. Okay. Now, what makes a church a bona fide club is kind of the next question. Well, the easiest way to explain it is that all entities and all assets must be owned and operated by the church. Now, for most of y'all, some of you that are in a faith-based organization, most of the time this is the case. All entities and all assets are owned and operated by the church, so they get to have this, we only hire these groups of people, okay? Now, where I say some religious organizations may not be eligible, this normally, not always, but normally is going to be your mega churches, where they're very, very large, and the church does not own all entities and all assets. You normally have investors that have a stake in the property and the assets. At that point, they're no longer a bona fide club, and at that point, they cannot have those type of rules that they only hire, Christians, or we only hire Jewish people, or we only hire whatever. At that point, this kind of goes out the window. All right. Those of you that have taken some of my classes, I give this advice quite often. And I think that this is a great area to give this advice. If you want to keep yourself out of trouble, I would pucker up and give this a big kiss. And y'all know what that means. Keep it simple, silly. I changed the last word. All right, keep it simple. This is a topic right here that can go south very quickly and get you into a lot of trouble really, really quick. So sometimes it's best just to stay away from this topic, all right? Especially in an employment relationship, okay? Now, those of you that are on the webinar or will be watching the webinar later, if you're not part of a religious institution, then of course you cannot discriminate against anyone based on religion. As long as they agree to perform the duties on the job description, that's what you've got to look at. All right. Now, those of you that are part of the church or associated with the church, then again, as long as you're a bona fide club, you've got some exceptions right there, and you can limit, this a little bit. All right. So for those of us in the private sector, for example, I actually have a faith-based component in my program where we do some Bible studies and sing some religious songs and stuff. But I have that in my job description. So anytime I'm interviewing an employee, I'm going to give them a copy of the job description that they're going to read over before the interview. And that job description is going to list every single thing that I expect them to do in detail. All right. So then when I interview them, the first question I'm going to ask is, did you have an opportunity to read the job description I gave you? And if they say yes, I move on. My next question, are you able to perform all of the duties listed on the job description, yes or no? And tell them the only way they can answer that question is by saying yes or no. Can you perform all of these duties? If they say yes, I would have them sign the acknowledgement right then and there that they can perform all of the duties. I would not move forward with the interview until they sign that acknowledgement. Okay? And your job description might say, we teach a Christian-based program. We sing I Love Jesus songs. And as long as that atheist that is applying for the job acknowledges that and says, yes, I will perform these duties, and they sign it, then that's all that matters. All right? So it's really important right there that job description, cover everything. Now, a lot of times people say, well, don't you want to know what they can't do? And the answer is no, you do not want to know what they can't do. For example, your job description may say something like, you must be able to lift 50 pounds at any time during the day. Well, if you have a person that comes in and says, well, I can't sign this acknowledgement, I can't lift 50 pounds due to a back injury. Well, now they have just disclosed that they have a disability. So when you don't hire them, they're going to turn around and sue you for discriminating against their disability. Or if they say, well, I'm not a Christian, I can't teach a Christian curriculum, I can't sing I Love Jesus songs, and then you don't hire them, they're going to turn around and sue you for discriminating against their religion. So that's why that job description question needs to be a yes or no question. Once you have knowledge, you have responsibility. And so you don't want responsibility when it comes to protected classes. All right. Now this right here again is during the interview process. You're only going to ask questions that are related to the job that you are hiring for, and that's it. All right. I'm going to move forward unless y'all have any other questions about religion, because we could spend 3 hours on that one if y'all really wanted to. There's a lot to go over, but I'm trying to watch the clock. All right, 2 little bitty protected classes right here. Age, you become protected at the age of 40. So after the age of 40, someone cannot discriminate against you for being too old. All right. Now, again, this is very outdated. I think that if this was rewritten today, it would probably be like 60. But 40 is the magic year right now. However, even though that's specifically what this class is geared towards, is discriminating against someone being too old, you can also get in trouble for saying, well, I would really like to hire you to be my pre-K teacher, but you sure do look young. I don't know if my parents are going to take you serious because you look young. That can also get you into some legal trouble. All right. let me back up just a second. I just thought of something that I failed to mention at the beginning of the webinar. One of the reasons why we are going over these protected classes, because some of you might be asking the question, well, Texas is an employment at will state. So don't I have a legal right to terminate an employee at any time for any reason? And yeah, technically the answer is yes. We are an at-will state. We do have the right to terminate at any time for any reason. However, if the employee is able to prove that they were discriminated against a protected class, then they have a right to sue you for wrongful termination. So that's where it gets pretty serious. The other reason why we want to put a strong focus on this topic is that most insurance companies will exclude discrimination lawsuits from their coverage. So you need to go back and look at your liability insurance, or if you have employment practices policy, an employment practice policy, you want to make sure that discrimination lawsuits are covered. Most of the time they are not, so you've got to be careful with that. Okay, gender. Now, ladies, you are automatically protected by law. Women are in a protected class. All right. Now, men technically are not protected. However, working in the early education industry, men only make up 3% of the workforce. So we are considered minorities. So because we are considered minorities, we now fall into a protected class. So what does that mean to you? Well, you cannot write a policy that says something like men are not allowed to change diapers, okay, or men are not allowed to work in an infant room. You will get sued for having those type of policies. Now, you might be asking yourself, what man would sue me for having a policy that says men cannot change diapers? Well, the man's probably not going to be the one that sues you. It's actually going to be the female employees that sue you for having this policy, because they're having to carry the brunt of the work. All right. So bottom line is you cannot discriminate against gender. All right. What you allow your females to do, you have to allow your males to do, and vice versa. However, this is a whole nother webinar right here. You also have to protect your employees. And you also have to put practices in place so that your employees are not falsely accused of doing something that they didn't do. And we see this quite often in our industry, where men working with young children are falsely accused of abuse quite often. All right. So even though you cannot discriminate against gender, you also have to practice good risk management. All right. And so that makes it very difficult, and you have to be very creative at this point. All right. Basically, you're going to protect all of your employees the same way. You're going to train your female teachers the same way you train your male teachers. You're going to put restrictions on the females just like you do the males. Bottom line is that you want to make sure that all adults are supervised by other adults, so that you can avoid these type of situations. But that one right there gets tricky. Like I said, that can be a whole nother webinar right there, just on how to protect your male employees from being falsely accused of doing something, or how to get your families to feel comfortable with male employees in the program, because a lot of times that comes up quite often, unfortunately. Trust me, I know I've dealt with it my entire career. All right. All right, I'll move on unless y'all have any other questions. Then we get into the other big one, pregnancy and disability. Now, these are two completely different protected classes. I put them together on the same slide because they're kind of identical to each other. They are different, but they're identical. Um, Basically, you must make accommodations for these individuals if you can afford to do so. All right. So if you have an employee that is pregnant, if you have an employee that has a disability, the pregnant employee is going to fall under the Pregnancy Discrimination Act, PDA, Pregnancy Discrimination Act. The disabled employee is going to fall under the Americans with Disability Act. Both of those laws are very similar to each other. There's one big exception, and I'll get to that. If you have an individual that is pregnant or disabled, they don't get to make the rules. Okay, so if you have a pregnant employee that comes in and says, well, I'm pregnant, I need to sit down more, or I'm pregnant, I can't go outside, or I'm pregnant, I need to be moved to this other classroom, whatever, they don't get to make those rules. Modifications, recommendations for modifications must come from a healthcare professional. All right. So when you have an employee that gets pregnant, one of the first things you want to do is send them to the doctor on the next doctor's appointment they go to, send a copy of the job description, and have the doctor put that job description in their file. That way, when they do need a modification, that comes from the healthcare professional. If you are able to make that accommodation, you must do so. However, I did put here on the slide that you still must meet minimum standard expectations despite the pregnancy or disability. So you have to still meet minimum standards. Saying I'm out of ratio because I have a teacher that's pregnant is not going to get you out of a deficiency. So if you are in a situation where the modification is going to put you at risk of being out of compliance with licensing, then you may not be able to make that modification, meaning the person may not be able to work there at that point. All right. But you're going to do some due diligence. You're going to do some documenting to be able to support that fact. All right. Now, I told you there are a couple of differences between pregnancy and disability. Under the Americans with Disability Act, you must make those accommodations for disabled children or employees if you can afford to do so. And that's kind of a period. Bottom line right there. Pregnancy, if you have less than 50 employees, then technically you're exempt from the Pregnancy Discrimination Act, meaning that if you have less than 50 employees, you technically do not have to make accommodations. However, I don't like mentioning that to y'all because even though you have less than 50 employees, you're technically exempt. I don't have to make accommodations, but if you don't, then that pregnant employee could cause a lot of drama for your business because the second you deny their accommodation, they're going to go to Channel 4 News. Channel 4 News is going to show up on your doorstep. You're going to be blasted all over social media. It's going to be a nightmare. You might want to follow the Pregnancy Discrimination Act, even though you may be exempt. It's probably the smartest thing to do right there. All right. And right there. And if y'all have any questions about any of this material, you can email me later on. You can call me later on if you don't feel comfortable asking the question right now. But like I said, bottom line is that healthcare professional gets to make the recommendations. If you can afford to make that accommodation, you've got to do it. If you can't, then you can't. They may not be able to work there at that time. Now, the other difference between these two is that with a disability, you must make accommodations for a disability as soon as it becomes apparent. So the employee doesn't necessarily have to tell you about the disability in order for you to make accommodations. If the disability is apparent, you see it, then you've got to make the accommodation. For example, you see an employee that has a hearing aid. They've never told you about the hearing aid. Nothing has ever been said about it. They've kept it to themselves because they don't want to be treated different. But you saw that hearing aid. The moment you saw that, it became apparent, you are now required to make accommodations. All right. So that means that when you have trainings, when you have a staff meeting, you may need to hire someone to do sign language. You may want to make sure they're sitting in the front of the room, whatever that accommodation may be for that specific person. But that's where disability and pregnancy is a little bit different, because disabilities, as soon as it's apparent, you've got to make the accommodation. All right. All right. Last slide right here. I got 7 minutes to go over three things. They're pretty easy though. All right. Veteran status is a protected class. You cannot discriminate against someone who has served in the military or is currently serving in the military, National Guard, those type of situations. The reason why people normally would discriminate here is that we're looking for long-term employees, and they're afraid that they're going to leave or have to be gone for long periods of time. And of course, the post-traumatic stress syndrome that sometimes comes along, people fear that. So they are protected. You can't discriminate. And then this also may apply to a military personnel spouse, meaning you can't discriminate against an applicant because they tell you that their spouse is in the military. Again, we're looking for long-term employment. As soon as you find out they're married to someone in the military, the first thing your brain says is they're going to be short-term because they're going to get transferred. They're going to be gone in 6 months. So rightfully, there's some protection there so that these people are not discriminated against. Okay. Marriage status is something that's specific to the state of Texas at this time. So you cannot discriminate against someone for being single, for being married, for being divorced, for being widowed, for being a single mom with 2 kids. You know, they've got some protection. The single mom with 2 kids is the reason for this protection. A lot of people will discriminate against that applicant because they assume they're going to be out of work more than the average person because they have no support system in place. So again, you can't discriminate right there. Yeah, I just got a question. Who can we discriminate against? Well, hopefully nobody, because we want to treat everybody equally. But yeah, it does seem that way, doesn't it? Now, with marriage status, the only exception to this one right here is that we're going to circle back to religion. And if the marriage status conflicts with a religious belief and that church is a bona fide club, at that point, that's going to supersede right there. So if you're part of a religious organization that frowns upon divorce, and they decide to fire an employee the second they get a divorce, they can use that as religion rather than marriage status. Again, that's a sticky one. I would personally recommend that you stay away from that because they're going to go straight to Channel 4 News and cause a lot of drama for your school. Is it a winnable court case? Sure. All right. If you meet all of the criteria. And then last, sexual orientation and preference became protected back in 2015. So that again is a protected class. However, y'all know that that is being challenged at this point in time, kind of, sort of. It's kind of a tough one right there. But I mean, y'all see everything that's on the news right there, especially because this one can go back again to religion. And someone could try to discriminate against sexual orientation from a religious standpoint. But on the flip side of that, even before 2015, we've seen protection for sexual orientation and preference under gender discrimination. So again, it just depends on the side of the court and what judge and jury you're going to get that day. You know, and a lot of these things do come down to just that. And that's why I kind of saved that comment for the end. When you're making a decision in your program, whether it's a hiring decision, an enrollment decision, a termination, a kicking a child out, or a de-enrollment, I always want you to ask yourself, how would a jury look at this situation? All right. And that's a good kind of checks and balance of what do I do here and how do I make this decision, is how would a jury look at this? And that really kind of helps you sometimes with your decision on how to handle things. Now, I do want to say one more really quick thing before we end our webinar. Anytime you are going to discipline or terminate an employee that falls into a protected class, I would always make sure that you review your documents, you know, 2 or 3 times before you make that decision. Make sure that you have everything thoroughly documented, I's dotted, T's crossed, and even have a consultant or an attorney look over the situation before you do whatever you're planning to do. Anytime it involves a protected class. Now, I'm going to add one more thing to that. Anytime you plan to terminate or discipline or de-enroll a individual that is pregnant, that is disabled, or at any time during the relationship has filed a workers' comp claim against you. In those 3 situations, I would always consult an attorney before you discipline or terminate them, okay? And again, I'll go over those. Pregnancy, discrimination, and anyone that has filed a workers' comp claim at any time during the relationship, always consult an attorney before you take action. So those are the big 3 right there. All of these other protected classes, just make sure that you're very thorough on your documentation and that the reason for the separation is specific to the job expectations and has nothing to do with their class. All right. So focus on job expectations. These 12 items that we went over today should never be discussed in an employment relationship. Okay, so you want to stay very, very clear of that. I got a question. Is cancer and cancer treatment a disability? Absolutely. All right. That does fall under the Americans with Disability Act. Now, there are different levels of protection depending on how severe the situation is and how much treatment is needed. But yes, it does fall under ADA. However, this is definitely one that I would go back to. The minimum standards expectations still have to be met regardless of the employee situation. So, you know, the classroom is in ratio, the children are properly supervised, supervision is defined by sight and sound, your emergency preparedness plan is able to be, done at any point in time. And depending on how severe the treatment plan is, not just for cancer, but in any of those situations, is that going to put a burden on the job expectations? So that's where you've got to look at the documentation from the healthcare professional and what type of accommodations are needed for that person. All right. And, you know, that's a tough one because emotionally and morally, we want to do the right thing and we want to support this individual that's going through this life crisis, and we want to be there for them. But at the same time, we also have to run a business and we also have to stay in compliance with minimum standards. We also have to make sure that our children are safe and not at risk. So it's very hard to be able to balance those situations right there, and it's tough. All right. I got a question. Children diagnosed with ADHD are also have ADA protection. Absolutely. Now the key word right there is diagnosed with ADHD, and they have to be diagnosed by a healthcare professional, not by mom or dad who's been on WebMD. Okay, so it has to be a real diagnosis. But you know, that is a great example, Lisa, of medication being administered, and you may choose not to administer medications in your school and have a no medication policy, which is totally fine to have that policy. However, anything that falls under ADA, you would have to do. So this would be an exception to that no medication policy because the medication for treating ADHD is considered a reasonable accommodation to a special need. So you would be required to give that medication in that situation regardless of your policy. All right. That would also include EpiPens. That would also include breathing treatments, nebulizers. Children with diabetes and doing blood sugar testing also falls under that same ADA umbrella. Okay, so that was a great question right there. All right, fantastic. So we went a little bit over on our time. If y'all have any additional questions, like I said, you can call me, you can email me. Y'all know how to get a hold of me. Hopefully, I will see most of you at our weekend mini conference coming up starting in September. All of that information is on my website, dates and locations and all that good stuff. Thank you very much for attending my webinar today, and I will see you at a future webinar or mini conference. Everyone have a wonderful rest of your day.